The personal injury lawyer is taking the time. They're bringing their experience, their resources, the time to prosecute a case, right? It's a risk. You advance a lot of costs and time, and you may not recover. It does happen once in a while, but hopefully you know going into a case what your chances are of recovery and what your client's going to end up with.
Welcome to Hot Docket, the show where we talk about winning marketing strategies that have built the most successful law firms.
Join us every 2 weeks for the latest trends and tactics to grow your law firm.
Hey everybody, and welcome to the Hot Docket podcast. Today we're going to be talking about personal injury in Florida. It's pretty weird. And we're going to be joined by Eric Mausner, one of the founding attorneys at boutique personal injury law firm Mausner Graham Injury Law. So that'll be a good time.
Yeah, so personal injury is a very congested market in Florida, and you've got some of the biggest personal injury firms in the world that either have offices there or their headquarters there. So it's definitely going to be interesting to hear about from the folks that are kind of in that fight.
Yep, agreed. With that, let's say hello to today's guest, Eric. Eric, thanks for joining us.
Thanks for having me.
Of course. So to start out, can you just tell us a little bit about your journey to start Mausner Graham and why personal injury?
Sure. So, well, I've been practicing for 12 years now. I started my career as a prosecutor, and I knew instantly when I was leaving government that I wanted to go into personal injury. It's transitioning from being a prosecutor into personal injury is a nice thing to do. It's trial work, it's litigation. You get to help people. You get to help victims of injuries, victims of crime. It's a nice way to work with clients because you give them access to the civil justice system, and they don't pay you up front. You only get paid if you recover. So that's a really nice way to work with clients. Most clients are like, how much do I owe you, right? Or, I have to hire a lawyer after something goes wrong. But now with personal injury lawyers, we only get paid on contingency. So it's a very nice way to work with clients as well.
Yep. And like contingency fee, everybody has their own way to tell clients free unless you win. What's your kind of like messaging?
Yeah, I mean, look, there's nothing original. All personal injury lawyers don't get paid unless you recover, right? No fees or costs unless you recover. So, and we explain to clients, look, the personal injury lawyer is taking the time. They're bringing their experience, their resources, the time to prosecute a case, right? It's a risk. You advance a lot of costs and time, and you may not recover. It does happen once in a while, but hopefully you know going into a case what your chances are of recovery and what your client's going to end up with.
With giants in your market like Morgan & Morgan, Dan Newland, Rubenstein, all these folks in Florida, how do you succeed as a smaller firm, and what are some of the ways you would differentiate yourself from some of the mega firms out there?
You get that question a lot. Everyone's always afraid of the big advertisers, but the truth is the population's growing. There's lots of problems, and a lot of people don't want to go to those firms. Smaller firms like my firm, Mausner Graham Injury Law, we give our clients a lot of attention. Clients get myself and my law partner. We have a lot of technology, so clients get automation. They get texted. There's a lot of ways to reach out to us. We're very accessible, and we like to give our clients a lot of updates, whether we're doing it manually or the system is sending out automation, emails, or texts to clients. There's a lot of things we can do to differentiate to keep our clients happy. And, I think when you do go to a smaller firm, you're going to get better attention. You're probably going to get better representation as well. And that's nothing to say anything negative about anyone at those firms. I know people at those firms. There's fine lawyers there, but those are big machines, and clients fall off. Clients complain sometimes. You do hear that.
And on that subject of automation, can you walk us through some of like the most interesting or the most effective flows that you've built out?
Yeah, our case management software actually texts clients. So, and not to take away from the gravity of a personal injury case and the seriousness and what somebody's going through, but we have a system in place that kind of like a Domino's pizza tracker. It gives you a text update along the status of your case. Clients love it. And the idea is that clients are always connected. They know what's going on. And one of the things I hate, one of my pet peeves is the client who says, I don't hear from my lawyer. I haven't heard from my law firm. I don't know what's going on in my case. I like to avoid that at all costs, and technology can help with that.
Yeah. And it makes sense to fight the battles that you can win, right?
Has there been any technology you've put in place that have helped speed up the timelines for cases?
I think case management software does do that. So we know the average length of a case in pre-suit. We can start to set client expectations. This case might take 6 to 9 months, might take longer. Litigation might take 1 to 2 years. So the system actually helps us with reminders and the automated updates and helps us move along cases. And then it also does help us with medical management. We want clients to get healthy, of course. That's the primary purpose of a personal injury case. The second purpose, of course, is to get paid, but you want your clients to get healthy. And the system will help with the medical management as well.
Yeah, I was talking to one of the folks I stay in contact with at one of the big firms, and they were saying like that is the number one problem that they are trying to solve with automation and back end processes is how to make sure people go to their appointments, how to make sure that they're getting the treatment they need, and it's not like a trivial problem. It's hard. It's hard to solve.
It's a hard part of the business, and the only way to solve it is technology and staff. It has to be someone's job calling clients. It has to be technology sending them updates. And it alleviates the lawyers, it alleviates the staff. It sets expectations from the beginning of cases all the way into settlement, whether that's at trial or mediation or at any point in time. You want to keep the client informed. You want to keep expectations realistic too.
Yep, makes sense. And on this subject of talking about what the experience is like for clients, I think it's a good segue into talking about Florida as a whole. It's not exactly known as a plaintiff-friendly state. Tort reform seemingly has killed first-party insurance dispute as a case type, at least according to like a lot of the folks we've talked to. I'd love to just hear from you. How is this bias manifested in the PI world? Are you often facing an uphill battle?
Well, yeah, it's always an uphill battle. Every case can be a battle against an insurance company who wants to pay you pennies, right? But tort reform, yeah, what it did was, well, it changed the statute of limitations from 4 to 2 years, right? It changed negligent security law. It changed certain things, what you can do, how you board your meds and work on letters of protection. It changed bad faith laws. So now the insurance companies may not uh, don't seem to care about paying on time, right? There's no what's the penalty if they don't pay your client um, on time, right? There's a 90. They've changed the laws. I won't go into all the details, in this podcast, but and obviously the big one, which I could have said first, is they've now comparative negligence is 51% in the state. So if the plaintiff is more than 51% negligent, plaintiff gets and is found liable at trial, you get zero. 51% more on the plaintiff at trial, you're getting zero. So that's a big change in Florida. In the past, it was called pure comparative negligence, where if your client was 25% at fault or 30% at fault, you could still recover, right? Your award just would get reduced by that 75 or 70%, right?
Yeah, we've heard a
Now
lot
you
of.
get now you get zero. So the insurance companies are going to start to test that. They may not pay out on tough premises liability cases. They may not want to pay out on car crash cases where multiple parties are at fault. We're going to find out. We're pushing cases to trial, and all we can do is push back. A lot of states have 51%. Pennsylvania, for example. There's a lot of other states in the country that have comparative fault at 51%, and they survive. So we'll keep the push going.
I think it was North Carolina was a firm that we're working with that has that in place. I don't know if it's 51% or
There's four jurisdictions in the country that have what's called contributory negligence.
mm-hmm.
If the plaintiff is 1% negligent, he's barred from recovery, he or she. That's North Carolina, Washington, D.C., Virginia, and Maryland.
Yeah. I knew they had a particularly difficult time, and it becomes like the focal point in a lot of their cases is that negligence.
Look, what this is going to do to most plaintiffs' lawyers in Florida is going to make you a little more selective. A tough premises case, like a tough slip and fall that you might have taken under the old law, it's maybe something you pass on now because of that.
So Florida man is a trope for a reason. Do you think the injuries and cases in Florida are especially out there? What's the craziest one that you've personally seen?
There's probably a long list. Some of this can be confidential. You don't want to speak without client permission. But I remember I had a case where I had a client running from the cops, he tried to climb down. He was in the building running around from cops, hiding from the cops for an hour. And he's climbing up and down balconies. He's in stairwells. And he ultimately breaks into an apartment, running from the cops, tries to climb down a balcony on the 20th floor, falls, and dies. But we were able to recover money after that. And, even despite his criminal conduct, despite his criminal record, we were able to argue negligent security and recover. So that was it's just an example of a crazy case that's awful and sad, but we're able to recover money for the survivors.
It also sounds like an instance where, people always ask this question, why do I need an attorney? Why can't I just do this? I think fighting like a police department or a city is a good example of why you probably do need a lawyer working on your behalf.
Yeah, or if you get really sick, do I need a doctor to help me? It's like why wouldn't you go to a professional who has experience, who's trained in law, who knows your rights, who can file a lawsuit on your behalf? The insurance companies know this. They know this. They're going to take advantage of the public. They make money by not paying out money. It's a simple formula, right? Pay your premium, and when it comes time to put in a claim, you're going to get ripped off if you don't go to counsel who can help you build damages. The average person doesn't know what economic and non-economic damages are in a personal injury case, right? Do you know the value of pain and suffering, mental anguish, inconvenience, disability, disfigurement, right? Do you know how to present those to an insurance company? Do you know how to present those in court? The average person doesn't know how to do that. So, the person who says, I can do this myself, usually it's a bad idea, but I'll give you the law school answer. Yeah, maybe it depends.
Yeah, I think the number we've seen thrown around is typically attorneys will get something like 3 times the amount than if a client tries to do it themselves and negotiate with the insurance company.
Yeah, I don't know the statistic, but that I would imagine it's at least 3 times. And if you're filing lawsuits, it's going to be much more. Much more. You have to put a lot of these cases into litigation to maximize the value. Even if they end up settling right away or getting to mediation, you have to file. And you want to be with a law firm that files lawsuits and litigates. You don't want to be with an injury lawyer or a non-injury lawyer out there working your claim. And you don't want to go to a law firm out of state, right? I just got a case from a New York lawyer who was working on a Florida case. And the case got screwed up. New York lawyer the firm didn't put the attention into it. They didn't set the medical treatment up properly. The client wasn't referred to the right doctors. The case wasn't worked up from the get-go by this New York lawyer. And when they sent the demand, State Farm offered him $300, right? Prime example of why you want to hire a lawyer in the jurisdiction where the accident occurred immediately after it happened.
Reminds me of the hometown lawyer. We had a conversation like recently with another firm, and they specialize in small towns and why it's so much better, working with an attorney that lives in the community, is in the community, and kind of speaks to exactly what you're saying.
Yeah. So you brought up an interesting point where you want to go, if you are a client searching for a firm, you want to pick a firm that is going to be able to give you attention and that they're actually filing the claims and they're going to trial. How, if you were a client, would you select a firm based on that criteria? Like, how are you going to know that they're actually taking claims to trial?
Those are questions that you should be asking the law firm up front. Do you file lawsuits? Do you litigate? Do you go to trial? Do you have enough cases? Do you have time for my case, right? You can ask some of those questions up front to feel out the law firm. Who's going to be working on my case? Is it you? Is it your associate? Is it a paralegal? If you really want to take it a step further, you can always look up lawsuits as well. But I would ask some of those questions up front. If I were to hire a lawyer, let's say for a non-personal injury matter, I would ask those questions as well. A corporate transactional lawyer, I would ask about their background. How many cases are they handling? What are the expectations? When's this going to be finished? Things like that. So I'd ask questions. Same way you would ask a surgeon who's about to perform surgery on you, right? How many times have you done the surgery? How long have you been practicing, right? What are the risks, et cetera?
So if you were doing that, how many cases on an attorney's docket is too many? where if you see that they have X amount of cases, where would the line in the sand be for you? Like real cases that are going to go to trial, not pre-lit
Yeah, so
cases.
this. We were having this conversation. I was having this conversation a couple weeks ago. This is going to vary from attorney to attorney, and it's going to vary depending on the kind of case. There's lawyers that can handle a ton of small volume cases, right? And then there's the lawyers who want to handle 10 to 20 mega catastrophic cases, right? For an average litigator, 40 to 50 cases in litigation is a lot. Some people say you can't handle more than 40. Some say it's 60. Some of these big firms, Morgan & Morgan, Rubenstein, those litigators might have 60 to 75 and queued up. Pre-suit's another animal. So, there's lawyers that are handling hundreds of cases pre-suit, which is monitoring clients' treatment and sending demands, right?
Yeah.
So,
have you noticed that when you onboarded software, you were able to bump those numbers, like from a firm that had nothing to bring on some level of automation? If you had to put rough figures to it, what would you guess?
It's night and day, actually. Having software does allow you to manage much more. It really does. I meet tons of lawyers out there, the old school kinds, young and old. They're missing out. They're refusing to change and adapt and evolve with what's going on with the tech. You can definitely handle more files using technology. That's for sure.
Cool.
And I haven't even implemented AI to do any of this. But there's a lot of lawyers using AI now, right? To read depots, to write demands, to write documents. AI is actually helping a lot now too.
That one guy got called out, right? And kind of recently for using AI. I don't remember the case type, but it was pretty famously called out.
I think there was an injury lawyer in New York, or there was a litigator in New York who used AI to write a motion and didn't check the case law, and the judge slammed him. That was in the news.
Ouch. So I want to circle back to going to litigation and just talk about Florida as a whole. So we talked about Florida man as a stereotype, and I think what that really means is or how people perceive that at least, is people in Florida tend to take risks. That's just like the stereotype and can be a little out there. Can you talk about whether or not that stereotype works against them in the court system when it goes to litigation?
I'm trying to understand your question. Look, Florida is a crazy state. There's 20 million plus people here. There's tons of problems. There's problems here that you and I couldn't even think of, right? Until it pops up on your Florida man on Instagram, and you're like, "Holy shit, did that happen?" Every case is different. If you're going to create evidence and commit a crime or injure somebody and it's captured, it's going to be used against you, right? So I think, is that where you're going with this?
I think it's more like, our insurance companies actively in the court system trying to argue more negligence type of grounds, because they're just saying as a whole, this person is crazy or this person is like reckless. And does that just happen more?
Well, let's put it this way. If you're putting information and putting things onto social media, the insurance company is going to get it and use it against you. So yes, if you're doing stupid shit on your TikTok or your Instagram, like, that's discoverable. And what these insurance companies actually do is the second the claim is opened, they'll reach out to the insured and they themselves will start looking at your social media if it's open, and they'll start capturing videos and photos, and those will be used against you in deposition and in court. That's for sure.
All right. So for lawyers listening that don't work in Florida, what would be the single hardest thing to acclimate to? Like, what is the most challenging or unique thing in the Florida legal process? Like the example you gave with a New York firm that took on a Florida client and probably planned to refer it out later. What would you tell folks ahead of time who would be referring cases to Florida firms, if they can, even, because I think they have to be barred in Florida to even do that, right?
Yeah, you do. And you have to get pro hoc vici, you have to get permission. So Look, I usually tell out-of-state lawyers that Florida is very litigious. Everyone knows that, and that's probably why there was tort reform and why there was rising premiums. Maybe that's probably a small component of it, though. There's a number of other reasons why insurance goes up. I wouldn't blame it on litigation. And in fact, I'm pretty sure the plaintiffs bar says litigation is not the cause for increased premiums. But I tell out-of-state lawyers that it's a litigious state and that cases go to trial fast here, especially on the criminal side. Cases go in front of a jury, at least pre-pandemic. The system's pretty clogged up now. There's lots of cases filed. Morgan & Morgan, I think, filed 25,000 tort reform. We filed a lot. Everybody filed cases right before tort reform. But I tell out-of-state lawyers that things go to trial here and that you have to be ready to litigate. Unlike other jurisdictions, and what I've noticed too about Florida, if you compare it to New Jersey or New York, it moves much faster down here, which is nice because you get a result quicker for your client. Client gets justice faster down here, I've noticed. But I'm barred in New Jersey and New York as well, and I'm from there. I just know that the system moves way slower up there.
So if you had to compare those timelines, what would you say the average case duration is in Florida versus New York?
From what I've seen just recently, if I can get a case done in 12 to 18 months in Florida, that might take 2 or 3 years up there.
That is kind of nuts.
And when I moved here to be a prosecutor, I tried as a prosecutor probably at least 25 cases in 3 years. That was substantially more than the lawyers in New York. The system moves quicker down here, even on the criminal side. So I've just noticed that myself over time.
Awesome. Well, Eric, I think we learned a lot in this conversation, and Florida is indeed weird, especially in the personal injury side. So confirmed on that front. Thanks again for joining us. And for folks to get in touch, if you want to just shout out, easiest way to get a hold of you, that'd be awesome. Yeah,
I'm very accessible on all mediums, but 305-344-HURT is our main line, 305-344-4878. And of course, we're on social media, MG Injury Firm, and the website's mginjuryfirm.com.
Thanks, Eric.
Thanks for having me.
Another good episode. Another pug groaning. I don't know what this is. That's becoming a theme.
Yeah, I feel like halfway through, she always jumps up, goes right up to the microphone, and just grunts or sighs.
Yeah, it's maybe a problem. I guess we'll find out. But yeah, no, as unsurprised, I guess, this is what we kind of expected going in, that, we were going to learn some things about why personal injury is weird in Florida, and we did. So that's been super eye-opening for me. And I think as we go forward, helping our clients grow and do the things we need to, it's also really helpful for us.
I think part of the reason personal injury is the way it is in Florida is the demographics, where you've got a lot of older folks and a lot of younger folks, and everyone's going up and down 95. So you've got high speeds with old and young drivers. It's bound to have a lot of injury.
95 is crazy. I'll tell a quick story before we hop off. I was in Florida for 2.5 years during the pandemic. I was at I was in Fort Lauderdale, Miami, then Fort Lauderdale. And I was 95 is 95. You see crazy shit all the time. But I was driving up from, I think I was actually driving home. We would do that drive once a year, go from Florida back up to New York. We were driving back, and there was a crazy traffic jam. And we're going very, very slowly, very slowly. Finally, we're creeping along the left lane, and there's just an active police shootout in the middle of the highway. And it's okay, I'm in Florida. This is happening. Anyways, thanks again to Eric for joining us. This was a great episode of Hot Docket Podcast. Join us on the next one. We hope you've enjoyed this episode of Hot Docket. We're your hosts, Bobby and Andrew, founders of MeanPub, the marketing agency for ambitious law firms.
Have questions about marketing or anything we covered today? Email us at bark@meanpug.com.